it is um, what will be the new framework for patents moving forward. So I'm going to ask that the presentation can be uploaded. Right. All right. So first slide, please. Right. So just a bit about, of course, the basics for those who may not be so familiar with patents and inventions. Invention is described as a new way of doing something or a new technical solution to a problem. A patent refers to an exclusive right granted by the state to an inventor, allowing for the exclusion of others from making, using, or selling the invention for a specified period of time. So it's a set of legal rights granted to inventors that give them exclusive rights over their inventions. Under the current legislation, which is the Patent Act of 1857, the period of protection for the patent is 14 years. However, under the law, the Governor General may extend the period for an additional 7 years based on certain reasons being established. So essentially, patents are for inventions. They can be for either a process or a product, or provide some technical solution to a problem. Under the current framework, the conditions for grant are that the patent must be, the invention, must be novel, meaning not known or used in Jamaica before, and must have some public utility. The current law requires the filing of the petition to the Governor General for the grant of the letters patent, the declaration from the inventor that he or she, or yes, he or she is the inventor, the true inventor of the invention, and a specification, a duplicate, detailing the nature of the invention, comparing it to what pre-existed in that area of science or technology, and showing how the invention now goes further and in fact is worthy of a patent. So the specification document, which is the key document for the patent rights, essentially is going to require you to discuss the prior art, which, as I said before, is what existed before your invention in your area that you are trying to provide a problem solver for. You have to outline the object of the invention, what are the benefits it will provide. You have to detail out all aspects of how it works, provide a summary or a definition of the invention. And most importantly, you have to outline the claims of the invention. This is what the invention is, what it does that goes beyond what was known in the prior art before the invention. That is where your patent rights will then be legally determined by virtue of the claims that then get accepted finally for registration. And of course, your drawings, if you have any, which may also help to illustrate or detail what your invention is and how it works. So the process at present involves JIPO as this central focal point, but also involving several other agencies. So the applicant would come to JIPO in person at one time, right? And of course, start the process there, where the forms are available. The Attorney General will be consulted in terms of the identification of an appropriate examiner, and then the documents will come back to JIPO before being again sent to that examiner, who will vary depending on the nature of the area of science or technology involved. It could be the Bureau of Standards Jamaica, it could be the government chemist, or others as well. And when that has been completed and it has been examined, it will come back then to JIPO for that process to be verified. You have to provide proof of publication in the daily newspaper or the gazette over a 4-week period that you have published details of the patent there. And then finally, when all the documents are ready and prepared and vetted, they can be sent to the Governor General's office for his official signature. Right? So several processes involved in the process under the current framework. Now, our new law, of course, has several changes, which we hope and are confident will make it easier for people to get their patents and, of course, simplify and modernize the process. So the new law, the Patents and Designs Act 2020, will repeal and replace the existing law and establish a modern framework for our patent system in Jamaica. So what are some of these changes that we will be looking at under the new law to come into place? Primarily, the patentability criteria is a fundamental change. Right? This is the established criteria internationally that must be proven, and so our law will now be consistent with that international best practice or standards. So the patent must be new, must involve some inventive step, must be capable of industrial application, and also must not be excluded under the law. So the new law does list certain exclusions to patentability, things which may not be patented. And again, these are quite standard, but weren't in our current legislation. So plants and animals, including DNA and cells, cannot be patented, right? Other than microorganisms, which can be. Essentially, biological processes for the production of plants and animals, plant and seed varieties, human body in all its developmental stages, inventions which would be contrary to public order or morality or prejudice the environment or human rights or animal or plant life, methods of surgical or therapeutic treatment and of diagnosis applied to the human body or to animals, discoveries, scientific theories, mathematical methods, schemes, rules, or methods for performing a mental act or doing business or playing a game, literary, dramatic, artistic, and musical works, and the presentation of information. All of these will not be subjected or be able to be patented under the new patent law. Other major changes, the law will now recognize the right of priority, which is coming from the Paris Convention, really which gives applicants the right to file a patent application in any country which is a Paris Convention member state within 12 months after filing in the first country, right, which is a Paris Convention member state. And so that then gives a priority date for filings in multiple jurisdictions, which is very useful, of course, for patent applicants when they're going global with their inventions. The law also authorizes the registrar to utilize external examiners to conduct examinations, searches, etc. And so we will, as we have been, continue to use external, but also internal as well. We had trained a person some time ago, and want to also continue in that process to build the local cadre of examiners available for us to use. Whereas now, plans are granted for a 14-year period, with a 7-year extension being possible, the new law provides for a 20-year period of protection, which will be consistent with the minimum standards under the TRIPS agreement. Right? That will be non-renewable. The new bill will also require the payment of an annual fee for the maintenance of the patent. It also recognizes employees' rights in inventions as well, which is a new introduction in the law. So invention by employees under the new framework will be recognized. The law provides for invention to be recognized as being that of the employer in certain circumstances that is made in the course of its duties. If it is concerning the duties that may be assigned to persons, if it relates to the employee who has made an invention that he applies to the court for and gets some compensation, but based on some agreement with the employer, these are cases where the employee will have the the employer will have the right to have his invention recognized. Next slide, please. Now, the law will also provide for there to be compensation for employees who have contributed substantially to the creation of a new invention. So the courts in that instance will be able to, if asked, to assess the extent of contribution by an employee and to order, some compensation for employees who make some substantial contribution to the invention by an employer. Next slide, please. Employees also, in terms of their employment contracts, will have some protection in terms of recognition that they can't have their rights in invention undermined by their contracts. And so this also is in the benefit or for the benefit of employees as well who are doing or working in inventive areas. Okay, please. The law also succinctly details the patent owner's rights. And so this is also very useful. I mean, not necessarily so fundamentally different, but it does clearly outline the rights of the owner to prevent others from exploiting the patent without the consent of the patentee, and similarly, using or authorizing any other exploitation of the patent without consent. Interestingly, the law speaks about co-ownership of a patent. So in that respect, if there's some dispute between co-owners, then one co-owner can apply to the registrar to have the issue of co-ownership determined by the registrar. That is a new introduction of the registrar's power in the patent framework, which gives the registrar some authority then to resolve those issues without having to go to any court. The law also outlines compulsory licenses that may be obtained. So where it is that a patent owner may refuse on reasonable terms to grant a patent license, then persons can apply to a court to get the court to order that the patent owner grant a license for a patent. This is also a quite new power in the law. Next slide, please. The grounds for that depend on whether you are a WTO owner or not, but essentially are that the demand for the patent or for the invention is not being met in Jamaica on reasonable terms, that the patent owner has refused to grant a license on reasonable terms despite being asked to do so, and that as a result, the establishment or development of commercial or industrial activities in Jamaica is unfairly prejudiced. In that case, the applicant can make the application to the court for a compulsory license. Next slide, please, sir. If you're not a WTO owner, then the grounds are similar. Essentially, that there have been some requests which have been refused for a license, and essentially that the local market is being unfairly prejudiced by the absence of this patent. And normally, this will be used for certain inventions which are of a national, public health importance, national security importance, those kinds of inventions, and therefore, at least there is some recourse to be able to, in the public interest, get these kinds of licenses. Non-voluntary licenses also, under the new framework, can be obtained by the government to use certain patents in, again, the public interest, national security, health, nutrition, or in the service of the government as well. That would also be, of course, on similar grounds. No exceptions to infringement. So the law, in its new version, will have these recognized exceptions to infringement, right? So for therapeutic or medical use, again, that's just a summary. But there are certain uses which can be exempted under the law. Private non-commercial purposes, experimentation for non-commercial purposes, experimental, educational, or research purposes, preparation of medicines in a pharmacy, used by a relevant ship or aircraft, import and resale of the product from somewhere else, and used in good faith before the filing date or prior date, can also recognize under the law as exceptions. And then, also very new to our jurisdiction is that the law will provide for and recognize utility models. These are inventions which do not meet the full criteria for getting a patent, right? Because they may lack some inventive step, but nonetheless, they are new and can provide some industrial application and public utility, and therefore there's a new category now of IP rights that we have in Jamaica as a utility model. It will be valid for 10 years from filing. It will, in most other respects, be treated as patents are, except that, of course, there will be no annual fees, and so it's going to be a more affordable IP right for your local inventions. Finally, the new law, of course, paves the way for the PCT, Patent Cooperation Treaty, which we are looking forward to as well, which will provide international patent registrations coming into Jamaica and for our local registrations going over to the world through the Patent Cooperation Treaty. So I won't say much on that. I know our other featured presenter from WIPO will speak on that, and so that's it for me, I think. Yes. Thank you all, and I'm open for questions during the program.
Thank you so much, Dr. Goffe, for that presentation. It was very extensive, and we are certainly happy to welcome this new provision in that we have been operating under over 163 years old legislation. So we're indeed excited for this new law that will be coming into place. And thank you again for that extensive presentation. We'll now move to our second presenter for this morning, Mr. Jason Wongsam, who is the Assistant Patent Manager here at JIPO. And he will be looking at the new procedures for the patent application in Jamaica. So over to you, Mr. Wongsam.
Morning, everybody. Thank you, Chantal. We will be looking at the procedures that we will be facing under the new law. Dr. Goffe went through the basic features of the law. So what we'll be looking at this morning is basically the steps involved. Okay, so first slide, please. Excellent, thank you. So we will be starting from section 10. The first part of the law basically sets up the many definitions under the law. So section 10 basically deals with the applications. So when we're looking at the applications of the patent, what you will be firstly filing the application on the form number 1, right? Which basically sets out a request for the grant of a patent. And attached to your request for the grant of the patent will be your specification. So it's a little different from the old law, where you're not going to be filing a petition as in the old law. You're going to just be filing a form number 1 and your specification. Next slide. So basically, your form number 1 looks like this. You will fill it out. It has basic information about the inventors and the priority, the title of the invention, all of these things, and then you will attach your specification. Next one. So yes, it will have your name, the inventors involved, if there's an agent involved, and the title of the invention. Right? When we will be looking at power of attorney, it will be in the continued practice of the office to submit a power of attorney if you're acting on behalf of a client, right? And this power of attorney will be required to be lodged at the Island Records Office of Jamaica. As it relates to assignments, right? Under section 103, will be where somebody becomes entitled by virtue of assignment. Form number 16 will be required, and it will be required that you attach any evidence to this form number 16, where you will furnish us with the evidence. The assignment again will have to be stamped, lodged in the stamped office of Jamaica. So the filing date under section 11, right, will be if all the requirements under section 10 are fulfilled, then you will get the earliest date in which all the documents have been filed and submitted to the office. So the earliest date that you complete all the requirements under section 10 will be the day that you will get your filing date. Right? Under section 12, we'll be looking at rights of priority. And in respect of the rights of priority, you have 12 months before the expiration to claim your priority, but the priority must be claimed shortly after, within 6 months of you filing the application. Now, you can claim priority for the same invention, and you will state the date, and it must be for the same invention. You must state the filing date, and it must be within 6 months. These are the conditions under which you can claim for the right of priority. Right? Right. Section 12 also says, right, an applicant may claim priority on the reference on Form 1 also. There's a section on Form 1 that speaks to priority. Next slide. Under section 13, you will give information on a foreign application, right? And this information, it will tell you will give us information about the date of any earlier applications made, any numbers in relation to those foreign applications, right? And any grants or registration as it relates. And this will be set out on the form number 4 in the new law. Right? Mention of inventors. Now, under section 14, you will be looking at the mentioning of inventors. Now, inventors must be mentioned. Now, in a lot of instances, it's not the inventor that usually files the patent, but in most jurisdictions, the inventors must be mentioned in the application, unless there is a declaration stating that the inventor does not wish to be mentioned. Okay. Under section 15, right, where the application is found to have 2 or more inventions, you can actually claim for, the office will actually ask you to split the applications into 2 or more, because you can have 2 or more inventions in one application. So if the office discovers that you have such an application, the office can ask you to consider splitting the applications. You will be given the original application date and any priorities that you might have. So you will have that benefit. Preliminary examination. So the registrar will determine, right, whether the application is in compliance with the requirements of section 9 and section 10. Right? Right? And if so, right, if there is any request for amendments, we will ask you to provide details, or if there are any amendments need to be provided, right? Section 17.1 says, unless the application is withdrawn or refused before that time, then we will proceed to publication, right? And we will be publishing in the Jamaica Intellectual Property Journal, which is a difference from how we publish now. So this will be a little easier for the applicants to publish, right? In section 18.1, right, before the application is granted, right, the applicant can make any amendments to the application should there need a right to make amendments, and this could be done on the Form 6 where any amendments could be done, right? Under section 20, right, where the registrar determines that the application complies with all of the requirements under section 4, 5, 6, 7, and 8, you will be required on Form 7 to request substantive search and examination. So this is where, as Dr. Goffe mentioned earlier, we'll be using our local cadre of examiners, which we were hoping to develop further throughout the process. Right? In section 21, right, where the examiner forms the opinion that the application relates to 2 or more inventions, he will examine the first application, and then he will ask you, if you are interested in filing a division for the second application, at which time you will have to file the division for the application and then resubmit and then file for the examination for the second invention. And you will at that time commit the examination for the second, right? Section 22, right? So this is the grant and the refusal. So once the patent successfully satisfied sections 4, 5, 6, 7, 8, 9, and 10, the registrar will grant you the patent. So in this law, it basically states what are the conditions for grant and what are the conditions under which you will get a grant. So these conditions are new inventive step, industrial application, exclusions from section 8, which really speaks to what Dr. Goffe spoke to earlier on, right? And that the application is correctly filed, right? Under section 24, basically states the term for the patent. Now, the term really is 20 years from the date of filing. So it will be 20 years from the date of filing, and you will have that time to enjoy the fruits of your patent, right? Under section 25, right, it speaks to the annual fees, right? And it says, as of from the grant of the patent, each successive anniversary thereafter from the filing date, the application for the patent will be, so there will be a prescribed fee in the second schedule for each year, and this will become due on each subsequent anniversary of the patent, and this will be laid out on Form 8. So each year you will pay for the patent on your Form 8 after the grant of the patent. So the next section speaks to the PCT, and as Dr. Goffe alluded to, we will allow Mr. Hernandez to speak on the PCT and give you the details of the PCT. And so, thank you. I hope you have any. If you have any questions, we will be more than willing to take the questions.
Thank you again, Mr. Wongsam, for that presentation and providing that overview of the procedures for new patent applications. I know it was very extensive, and so if it is that you have any questions, please feel free to put in the chat, and we'll be happy to address those at the end. We have a special segment for questions and answers. And our final presenter for today is Mr. Rolando Hernandez Vigaud, and he is from WIPO. He is the head of the Office Services section of the Patent Corporation Treaty, And today is extremely special for Mr. Rolando because he's celebrating his birthday. So on behalf of all of us here at JIPO, we'd like to say happy birthday to you, Mr. Vigaud. We thank you so much for taking the time to be here with us this morning on your special day. And we put the floor over to you now. So good morning again and thank you.
Okay,
Vigaud?
thank you. Yes, thank you very much. It has been very touching. Thank you. Can you see my presentation? Can you see my presentation? Okay, can you hear me?
Yeah, no, but that's it. The audio.
Okay, you can hear me, and I assume you can see my presentation. Unfortunately, I have been trying to activate my camera, but it says that there is a problem here. It doesn't work. I don't know why. Well, thank you for having me in this webinar. Thank you to the Jamaica Intellectual Property Office. As it was said, I'm going to make a very brief presentation on the Patent Cooperation Treaty with a special emphasis on the role of patent attorneys and applicants in general during the national phase. That is the area that will arrive later, but still will require more preparation from you all. That's the agenda of my presentation. First, we are going to address what is the PCT and compare the PCT with the traditional patent system. Then we are going to have a very brief look at the PCT timeline and analyze the scenario of a new PCT contracting state, what happens, how is the dynamic, and the entry into the national phase, to end with some PCT statistics. Well, I'm not going to explain again the traditional patent system. The Dr. Goffe already mentioned it. Well, this is based on the Paris Convention. This is at the heart of the protection of the intellectual property, industrial property worldwide. And the thing that I want to underline here is that the priority period of 12 months that is valid for the traditional patent system, it is also valid for the PCT. Here is the comparison of the traditional patent system and the PCT system. As you can see, in the traditional patent system, the applicant has 12 months to directly deposit his application in foreign countries. And when filing at the end of this priority period of 12 months, he has to be able to pay for translation, national fees, hire a local agent, etc. On the contrary, in the PCT system, the applicant, instead of filing multiple national applications at the end of the 12-month period, what it's going to do is file a unique PCT application that is automatically valid for the 153 member states. And this is going to give this applicant much more time, first to assess the value of his or her invention, and secondly, to prepare for the payment of the fees, the translation, and to hiring the local patent agents. That is going to happen only at the end of the 13-month period, according to the PCT. So what is the PCT? Well, it's an international treaty administered by the World Intellectual Property Organization. Now we have 153 member states One extremely important notion about the PCT is that it is a patent filing system, not a granting system. They are not international patents, they are not PCT patents. The patents still are national. The applications are the one that can be international under the PCT, because the decision on granting patent is taken exclusively by national or regional offices at the end of the national phase, when the national phase has started. The PCT, I should have said at the very beginning that PCT stands for Patent Cooperation Treaty. So only inventions may be protected via the PCT for using every kind of way of protection given by the national legislation to protect inventions. That is, you can protect via the PCT patents, utility model, etc. That depends on the national legislation. Here is a kind of timeline to show how the PCT operates. You can see here that here is the first filing. The applicant filed his application at the national office. Then, in the period of 12 months, instead of filing many national applications, file a PCT application. This filing is done before the national office that is going to act as receiving office of international applications. Then the international, what we call the PCT international phase, starts. And the first thing is that the applicants at 16 months from all these periods counted from the priority date will receive an international affairs report and a written opinion. These are a document of a very technical nature, will give the applicant technical elements about the value of this invention that he's trying to protect vis-a-vis national phase. That is, this international affairs report and written opinion will tell the applicant if this invention that he's trying to protect fulfill the requisites of novelty, inventive step, and industrial application. But this is only an international report and a written opinion. It doesn't imply that the patent is going to be granted. It's just information for the applicant. And 18 months from the priority date, the international publication will happen. The international publication is done by the International Bureau here in Geneva on electronic format only, and all international applications filed under the PCT are available freely for consultation in the patent scope website that is in the WIPO website. These three steps in red are mandatory. All international applications have obviously to be filed, then to be subject to the international affairs report and the written opinion, and then they have to be published. There are some additional steps that are optionals. There are alternative routes given to the applicant in case the applicant needs more information about the value from the technical point of view of this application. So we have the international supplementary international search request, the international preliminary examination, and so on. The PCT international phase lasts up to 30 months from the priority date. At this moment in time, the applicant has to say what he's going to do, and that's what we call the national phase. Then the PCT doesn't apply anymore, and what is going to be applied is the national law of every member state. We are going to see more of the national phase a little bit later. This is the same, but with another view, with another perspective, because as I mentioned, the C in the PCT stand for cooperation. And indeed, the PCT system is an international cooperation system in the area of patents that involves the International Bureau, the international searching authorities that are going to carry out the international search report and the written opinion, national offices in character of receiving office or designated or elected office. And you see it's just a communication, multi-channel communication system trying to rationalize the procedure for the benefit of applicant and for offices, for both of them. The situation of a PCT for a new contracting state. As you know, maybe you have read about it, since the PCT started operating in 1978, we have received more than 3 million international applications. But obviously, if Jamaica joined the PCT, these 3 million international applications are not valid for Jamaica because it was not a PCT member state. Actually, the fathers of the treaty designed a scheme that is very smart because the PCT will enter into force for a new contracting state 3 months after the deposit of the instrument of accession. It means that in case of Jamaica, deposit the instrument of accession to the PCT, the real operation of the PCT will start 3 months later. That is when Jamaica will become bound by the treaty itself. In practical terms, it means that international applications can be filed from Jamaica from this date, but also for entering into the national phase, only international applications filed after this date can claim this right of using the PCT to enter the national phase in Jamaica. That is very important because you will see that some applicant that doesn't understand very well the system will try to enter the national phase with applications that were filed before the date when the country became bound by the PCT. And that's not right. The filing date have to be after the date of when the state became bound by the treaty. And this is, again, the PCT timeline more detailed. But here, what I want to stress out is what law applies. In this gray area here, what is applied is the PCT regulation and the PCT and its regulations. You see this area cover all the international phase. Concerning the national phase, for the substantive issues, condition of patentabilities, technological fields that can be protected, etc., what apply is the national law. Concerning formalities, the PCT still apply for the moment of entering into a national phase. Later on, there can be some changes. I did mention already that the second stage of the international applications in the processing of the international application is the search report, the international search report, and the written opinion. This international search report and written opinion is drafted by what we call the international searching authorities. We have 23 international searching authorities at the moment, and it's going to be the National Office of Jamaica, in this case, the Jamaica Intellectual Property Office, that is going to determine which international searching authorities out of these 23 are going to be competent for Jamaican applicants. They can choose 2, 3, 5, 7, 9. There is no limitation, but it depends on the national office. And out of those selected by the national office, the applicant then can choose which one he would like to use. Now we are going to turn to the entry into the national phase. First, all decisions concerning national phase have to be taken by the applicant. No one is going to tell the applicant the term to enter into the national phase is approaching, of please be mind that your national phase opportunity window is next week. No, nothing about that. It's the responsibility of the applicant to control when entering into a national phase and where entering into a national phase. When you file an international application, automatically you are saying by default that you want protection in 153 PCT member states, in all the membership. So the moment when entering the national phase is when you really confirm out of these 153 member states, which one are you interested in protecting for protecting your patent. And that's important. But the first decision is to proceed with the entering to a national phase or just to drop the international application. As I say, during the procedure, the applicant will receive technical information, valuable technical information in the international affairs report and the written opinion that will tell him about the value from the point of view of patentability of the invention he's trying to protect. And this is information that is for decision making, because you may think that your invention is the best of the world, but then the international search report would tell you that there is 3 publications already in the state of the art that are similar or identical to the one you are trying to protect. So there is no possibility you are going to have a patent because one of the requisites is novelty. So in that case, you drop the application and you save the money of national fees, translations, etc. But in case that you have hope of getting a patent at the end of the procedure, then you proceed and you enter the national phase. And the decision is when to enter into a national phase. It depends on various factors. It depends mainly on commercial opportunities that the applicant can have, but also it depends on the field of the technology. For instance, I don't know, pharmaceutical products or pharmaceutical companies that are applying for a patent, they are not in a hurry to get the patent. Why? Because in parallel, they should get the authorization for commercialize this drug on the market, and this is completely separate from the patent procedure. So they cannot do anything with the patent alone. So they are not in a hurry. But on the contrary, if you see the behavior of IT companies, they are always in a hurry to get the patent as soon as possible because the sector is very dynamic. There is a technology always applying behind the other one and the other one because of the intensity of the research and development in this area. So the normal behavior or the smart behavior, because there is no normal, it's just for an applicant to use the PCT is to wait at least to have the international search report and the written opinion to enter into a national phase, because that's the value of the PCT procedure. One value is time, but the other value is technical information. So when you get this information, you can decide whether to enter or not the national phase. But this is up to the applicant. The applicant can enter the national phase from the following day of filing the international application up to 30 months from the priority period. That's the applicant who decide when entering into the national phase. And then the last thing is where, out of the 153 member states, the applicants can select these offices, national or regional, where he wants to get a patent protection because it's important for him for his commercial interest. At the moment of entering to a national phase, the applicant has to perform certain acts to announce the office that this particular PCT application is entering to the national phase, because he's the responsible person to tell the office, look, I have an international application that I want to enter into a national phase in Jamaica, in this case. The first thing is the payment of the national fee. The applicant obviously have to pay national fees, but again, may I remind you, is at 30 months when entering into a national phase. Then, if the international application is not in English, that is the official language of Jamaica, he has to file a translation, because obviously the national office will only work in English. Then another important thing is that the applicant has to fulfill certain special requirements that are particular to every jurisdiction. For instance, the appointment of an agent, the inventor oath or declaration, the assignment documents, etc. You see that the requisites are quite simplified, because at the same time, the International Bureau of WIPO, just to avoid duplication of work, will also perform certain acts to alleviate the burden of the applicant when entering into a national phase. The first thing is that the international publication is in the internet, but if the national office so requests, the International Bureau will provide the international publication to the national office, as well as the priority document. There is no need of filing a priority document, because you already filed the priority document when you file the international application. So when you are entering to a national phase, then the priority document is already on the file, and it's the International Bureau who will provide it to the office. Let's look at again to the issue of the time limits. As I said, the time limit is 30 months from the priority date. That's the general rule. Some countries give 31 months. Some countries give a little bit more, subject to a payment of a fee. But the time limit is sacred. Nothing change that. It's a fact that is 30 months from the priority date. So it doesn't matter what happened during the international phase, still the applicant have to respect the 30-month period for entering into a national phase. Concerning agents and common representative, the rule in the PCT that if you can act under the national law of a member state as an agent, then you can also act in the PCT procedure, because that's a question of national law. And agents can be appointed in the request or in a power of attorney. In the request, I mean in the international application request, in the form for filing international applications, in a separate power of attorney or in a general power of attorney. The PCT has another very interesting feature, that are the declarations. The declarations are not mandatory. You use it in the PCT if you want. If you don't want, you simply ignore them and go ahead. But the declaration has a big advantage for applicants, because through the declarations, applicant can anticipate certain national phase requirements during the international phase. What does it mean? For instance, the application has been, or the company has merged with another company, so the applicant is no longer the same. If you go with the international application filed in the name of one applicant and enter into a national phase with an application filed under the name of a different applicant, the national office will say, hello, what's going on here? Please explain. Give me a document of justifying this. And this is going to be subject to the formalities of the national law, as Mr. Wongsam just explained before me. But if you do that, if you declare this merge during the international phase, it is free of any requirement because it's taken as valid. And you see that declarations that can be made is the identity of inventor, applicant's entitlement to apply for and be granted a patent, applicant's entitlement to claim priority. In the case of the US, the declaration as to inventorship, and in the case of the problems with the novelty for being the invention exposed in a exposition, etc., then you can file a non-prejudicial disclosure or exceptions to the lack of novelty. This, I repeat again, is not mandatory, but is a particular advantage given by the system to applicants just to advance these procedures to the international phase and relax the requisites concerning these declarations. Well, I have already mentioned the national requirement, translation, payment of national fee, etc. These are other requirements. The priority document normally doesn't need to be translated. The priority document is going to be provided by the International Bureau to the office in the original language in which it was filed. But in certain particular cases, national office can request the translation of the priority document, but is only after the entry into a national phase, not before. Well, there is some recommendation for preparing the entry into a national phase. There is a need of really prepare the translation. The translation has to be accurate. The translation can, under no concept, should be used to include new subject matter. Have to be faithful to the original. You can include modifications, but sticking to the original subject matter disclosed in the application file as international application. The PCT also gives the opportunity to applicants before entering to a national phase to, let's say, fix the application again. That is to include amendments, to merge claims, to to do whatever it's necessary to increase the possibilities of success of this particular application according to the national law. But again, without adding new subject matter. The applicant have to monitor time limits. I repeat it all the time. In our website, we have a calculator of time limits. You enter your filing date or your priority date, and then everything is calculated. When entering into a national phase, it is extremely important to tell the office that this is a national phase entry because the treatment is different. And well, the payment of fees, before going here, I'll have something else to tell you. When I show you this graphic, here we are dealing with an application that was first filed at the national office and then claiming the 12 months priority filed as a PCT international application. That is the way of filing applications for more than 80% of PCT applicants. But there is small amount of applicants that files the PCT application as first application, meaning there is no previous application, there is no priority. You can go straight into the PCT system, but it depends on the interest of the applicant again. And let's now show you, to finish, some statistics. These are the top 20 origins in the PCT. That's statistics from 2019, last year. Last year, for the first time in history, China got the first place in the podium, and US, that historically was the number one, got displaced to the number two. You will see the difference is not that big in the number of application, but still is a lot of application. Last year, 265,800 applications were filed, meaning a growing of 5.2%. And last year also, under the PCT, 647,000 applications entered into the national phase. That is an enormous amount of work for the national offices. Concerning the applications by receiving offices, you will see more or less the same names, with the difference that the EPO appears here, that is not, it doesn't appear as origin because it's not a country, and also the International Bureau of WIPO, that is a receiving office, open to all applicants, is here in the list. The top 10 receiving office accounted for nearly 94% of application, meaning that these 10 have almost 94, and the rest of the world has almost the 6% of the applications. It's very concentrated, the number, the source of the applications. And that's the growing of in the number of PCI applications. You will see the PCT system has been always going up, except in 2009, where the big financial crisis happened. And concerning applicants, here you can see that the business sector leads in terms of number of application, the share in by applicant type. Last year, 86% of the applications were filed by enterprises, while the number of applications filed by individuals, universities, and even worse, the governments are very few. This area here are the businesses, the enterprises. This area are individuals. The light blue is universities, and the dark blue is the government and public research institutions. And we have here the distribution of applications by region, a comparison between 2009 and 2019. You will see that in the case of Latin America, nothing has changed. We keep with a 0.6% of applications. But in the case of Asia, the jump has been very big. They went from 32% to more than 50% in the number of applications. That means that Europe and North America, that previously were the main source of international applications, has decreased in favor of Asia. As I mentioned, the international searching reports and written opinion are issued by the international authorities. And this is the behavior of how much international authorities are in demand. You see the international authority that does more international reports and written opinion is the European Patent Office, followed by China, Japan, Republic of Korea, the US, the Russian Federation, etc. When choosing the international searching authority, it is important to take into account linguistic consideration, commercial consideration, but also the fees consideration, because every one of them charge different fees and give different fee reductions. So that's something that you have to consider. And that's in my presentation. I was speeding up because I'm taking too much time. So I'm open for any question or doubt that you will have.
Thank you so much, Mr. Vigaud. It was very, very interesting and extensive, very detailed as well. And I'm sure our participants have a number of questions for you as well. But as we enter into our question and answer segment, one of the questions that we got earlier was from Mr. James, Ray A. James, and he'd like to know, please let us know what the yearly maintenance cost of a patent. For a patent, I'm going to ask Mr. Wongsam to take us through that.
Okay, then from Mr. James, the annual maintenance of a patent is laid out in the Schedule B of the Act, and for year one, the cost of maintenance is 2,500, and in year two, it's 4,500. So each year, the cost goes up.
Okay, thank you, Mr. Wongsam, for clarifying that. We also have some other questions from Dr. Natsami today. One first question is, when is Jamaica expected to accede to the PCT? And I'm going to ask Dr. Goffe to respond to most of Dr. Cortiz's question. Dr. Goffe, the first question from Dr. Cortiz is, when is Jamaica expected to accede to the PCT? And what is the official date of entry into force of the 2020 Patent Act?
Okay. So in terms of accession, the aim is to complete accession before this year is out. As Mr. Vigaud had explained, when we do the deposit of instrument of accession, it takes 3 months thereafter to have it come into effect. So our hope is to have that deposited before the end of the year, and will then take effect 3 months thereafter. Dr. Corley had also asked what is the official date of entry into force. So the plan is to try to coincide so that the coming into force will be in or around the same time as when the treaty will come into force, right? That will be the PCT. So that is the plan. Otherwise, we'd have to bring into force a part of the act and let the international treaty parts wait until the treaty came into force. So that's the plan to coincide in the same time frame. You also asked who will carry out the search and substantive examination for national owned applications. This is a local and international search and examination procedure. What is the expected time frame? So in terms of the search and substantive examination, that will continue to be done by primary and external partners. So at present, and continue to utilize the services of the government chemist as well as the BSJ, Bureau of Standards Jamaica. But of course, yes, persons are free to also utilize other searching agents. We will, when the new law comes into play, be publishing additional persons who we have been a part of training for this and possibly assist in that regard. And the International Searching Authority as well can also be utilized, even though it's going for local applications. The time frame for examination really is going to depend on the nature of the invention. Some inventions will have more readily available experts to do the examination. Some are more complex and intricate than some. So the time frame will depend on the nature and complexity of the invention being examined.
Thank you very much, Dr. Goffe, for just addressing those questions. I'm not seeing any other questions in the chat, but I'm also seeing recommendations that we need to have more of these sessions done. So I guess we here at JIPO can put something in place to ensure
I see one more question.
Oh, there's one. Okay, I think there's one more question. Will the UK Patent Office be granted ISA status post Brexit?
Brexit, right. The UK IPO will be granted ISA status post Brexit. So in terms of the ISAs, then yes, I mean the EU IPO is one of those that we are looking at certifying for recognition by the office. Post Brexit, that is something that we'll have to look at carefully in terms of the discussion with the UK IPO as to how that would work. I mean, I guess it would probably depend on whether the UK IPO would be pursuing a different method of examination. If it's the same method that's going to be used by the EU IPO, then it may not be necessary to use. I think it's something we should definitely look at in discussion with the UK IPO.
May I add something?
Yes, go ahead.
Yes, no, because there is another question related to the UK that if the UK has withdrawn from the PCT. No, the UK is still in the PCT and will be in the PCT. And the UK Patent Office, for the time being, is not an international assessing authority. They used to be an international assessing authority many, many years ago. But then, when there was a moment that they voluntarily ceased to exist as international assessing authority uh, in favor of the EPO. Now, it depends on the UK Patent Office if they want to be again international assessing authority, since there is a procedure for that in terms of WIPO, and they have to comply with certain requirements that I don't know if they are ready for it. So that was it. Thank you.
Thank you for that, Mr. Vigaud. I see there are some other questions on the screen.
Yes.
Right. So can you just show the other question? If I have a patent application to submit, should I wait until Jamaica PCT is finalized? Mr. Wongsam,
Nobody keep taking the question off the screen now. Well, if you're interested in waiting on the new law to be implemented, that really is a personal decision. You have to make that decision depending on if you intend to go overseas with the application. So those are the things that you have to consider, and it's a personal. We can't tell you if you want to wait, but it is totally up to you.
okay. I'm not sure if I'm not seeing any other questions. Okay, another one. How will the existing patents be grandfathered after the next act? I think I'll ask Dr. Goffe to respond to that.
Right. Okay. Thank you, Ms. English. So the law speaks to that actually in the transitional provisions. What it provides for is that any applications which were commenced before the appointed day when this act came into force would continue to be governed by the pre-existing legislation. However, upon the coming into force of the new law, JIPO will exercise all the powers of the Attorney General in respect of the pending petitions which are filed under the old law, so that they will still be governed under the old law, but we will be processing them from JIPO.
They're asking which section was again of that? Can you reiterate for me?
The law is the transitional provisions which are located in section 127.
Okay, thank you for that. Let's see, are there any other questions? Okay, I'm seeing one more question. Will provisional patents be offered under the new law?
So no, we won't be offering provisional patents under the new law. No, we know something that is done in some jurisdictions, but we won't do so.
Okay, thank you so much. Do we have any other questions? Are you seeing any other questions? I think those are the only questions that we're seeing at this time. So that you have any further questions, you can always send us an email here at JIPO and we're happy to assist you with any questions that you may have. All our information can be found on our website, but before we end, we're going to ask each presenter just to give their final remarks. So I'm going to ask, first I'll start with Dr. Goffe first to give his final comments.
All right. Well, this is a process. Patents itself is not always easy to understand, and so we appreciate that it may take some time for persons to, grasp the full aspects of the patent framework, and of course, especially the new framework. But we look forward to engaging with all the stakeholders, the patent attorneys and agents, the applicants who are working in the different research centers, in the universities, etc., and the statistics that are set up. We are looking forward to being able to, through this new law, contribute to the increased registration of patents, the increased innovation that we have here in Jamaica. Recently, Jamaica increased our ratings on the Global Innovation Index, and so I think it's a right time for us now to have this new law that is workable, that is used to the full extent by our local scientists and other innovators. So we look forward to engaging and to seeing the good results of the new framework.
Thank you very much, Dr. Goffe. And over to you, Mr. Wongsam, with your final comments.
Dr. Goffe said it very articulately. We hope that we can serve the interest of the public a lot better than we have in the past as it relates to patents. So what we're hoping for is more engagement, a more robust legislation that can serve the needs of our public in a better way so that they can feel more protected under the patent regime. So that's what we're looking for, right? I think that's very important to note. So we hope that in the future it will be greater innovation coming out of Jamaica. We have the potential, so I think that's what we need to capitalize and commercialize.
Okay, thank you so much, Mr. Wongsam. Mr. Vigaud, would you like to give us your final comments?
Yeah, thank you very much. Very short. First, thank you for having me again. Secondly, please don't be afraid of the PCT. The PCT is maybe a very complicated treaty, but is this just because it's trying to be very friendly with the applicants, so it is easier to manage, and we are more than prepared to welcome Jamaica in the PCT family, and I think the Jamaica Intellectual Property Office is also very well prepared to face this new challenge. So just go ahead. Thank you very much.
Thank you, Mr. Vigaud, for your final comments. Also, yes, there's a question whether you be able to access the recording. Yes, we'll have it on our website and also on our YouTube channel. So you can always visit our website, www.jipo.gov.jm, or our YouTube channel, JIPO. So as we mentioned earlier, today is Mr. Vigaud's birthday. So I think it's quite in order for us to sing happy birthday to him before we wrap up this session. Happy birthday to you. Happy birthday to you. Happy birthday, happy birthday to you. Happy birthday to you. Happy
Oh my
birthday.
goodness.
And then we have Jamaica style. Happy birthday! Happy birthday! Happy birthday to you, Rolando! Happy birthday! Happy birthday! Happy birthday! Rolando! Happy birthday!
Oh, thank you very, very much. I'm really touched. You know, I'm alone here. It's almost 7 p.m., 6:30 in Geneva, 6:30 p.m. It's very cold, gray, and you have light my day. Thank you very much.
We are so happy that we were able to do that on behalf of our director. We also wish you happy birthday on her behalf. And we just want to say special thanks to everyone who participated this morning in this session, this webinar. First, thanks to our panelists, Dr. Marcus Goffe, Mr. Jason Wongsam, Mr. Vigaud. Also, special recognize Ms. Tracy Herdsman, who is also in the room with us, who is our patent examiner here at JIPO. Also, Ms. Shanisa Wright, who also assisted in sending out the emails, and to our technical operator, Mr. Bergman Hope. Just want to say thank you so much again for tuning into JIPO's webinar, and we hope to see you next time. Have yourself a wonderful rest of the morning and day. And again, happy birthday, Mr. Vigaud. And if it is that you have any questions,
Thank you.
or the PCT, you're welcome, and or the PCT, can feel free to follow us at JIPO or visit our website or send us an email, and we'll be happy to guide you in the process. Again, thank you so much for participating this morning.
Thank you very much.